Hi, Denise Naylor here, and welcome to News Views, Friday, the 26th of January 2018. Last week I talked about a little bit about the financial collapse of the public limited company Carillion and about the UK's productivity puzzle. I want to revisit both of those topics today. There's been a lot of press comment about the Carillion situation, and in particular, people have said the government must do something about the financial collapse of Carillion. Well, actually, the government has law that they can rely on. And in fact, this is a good opportunity to test the limits of that law. And that's what I want to talk about as my first topic today. So before I do that, just a brief history. In the United Kingdom, directors' duties were in the common law. They came basically out of the common law rules by case and precedent, with some equitable principles attached. Now, in common law case and precedent, you have to wait for somebody to bring a case, then the judge rules, either reinforces understanding that already exists or changes understanding, and it can take some time. And the Blair government wanted to introduce a more European model. He wanted to put directors' duties into statute, in other words, in the law. Now, the Companies Act 2006, the date is quite relevant here, took many, many years, in fact, to come to fruition. And full disclosure, I was actually part of the consultation. They asked if members of the public wanted to be involved, and I put my name forward, and that was quite interesting. Boxes of papers arrived at regular intervals at my front door, but it was good. I enjoyed it. But that's not the subject of today. So I'm particularly interested in this. Now, the section that I'm going to be talking about is section 172 of the Companies Act 2006. And before I read it to you, and I'm going to read it to you because I always believe in reading the original, I want to point out that the Blair government had a definite agenda behind this, right? And the real agenda that was behind it, which is a good thing, and I'm not here making any political point, is they wanted directors to take more long-term approach to decision-making, that the directors of companies are very short-term, just concerned about the profit, just concerned about the shareholders. That was the law. That was what they were required to do. And that's led to what's known as the short-termism approach. So that was really the underlying agenda behind this piece of legislation. So first of all, let's now go to 172, section 172 of the Companies Act 2006. Quote, this is section 1. A director of a company must act in a way that he considers in good faith would be most likely to promote the success of the company for the benefit of its members as a whole, and in doing so have regard amongst other matters to, and then they list 6 factors, but we've already heard the most important part here. Promote the success of the company for the benefit of its members as a whole. Now, an interesting author on this is Professor Andrew Kay of Leeds University Law School, and one of his papers he's published is called The Duty to Promote the Success of the Company. Is it fit for purpose? Very interesting paper. I recommend it to you. In that paper, he makes the point, which I didn't know. He says, Section 172, this provision led to more debate in the UK Parliament than any other provision in the whole Act. Wow. So this is obviously a very contentious point. But anyway, it passed into law, and that's the situation. Now, the reason I say the date is relevant is that research shows that the average age of UK company directors is 70. Yeah, you heard that, 70. Now, think about, and that's the average age, which means that there's a lot of people around who are older than 70. So 2006 provisions were implemented between 2007 and 2008. So they always bring the provisions in step by step. They don't usually bring everything in all at once. So that's 10 years ago, which means that your average director, and yes, it would be a Mr., if he is 70 now, would have been 60 10 years ago. And the point I'm trying to make is that that person would have had a whole lifetime of experience behind him. A whole lifetime of experience. I mean, obviously, that's why you get asked to be a director of a public limited company, because you've got a lifetime of experience. And it's very difficult. I speak from my own experience. When you've been trained in a particular way, it's very difficult to change your mind. Now, I'm not suggesting that these people aren't aware of the Companies Act 2006, after all, I read it to you. It's written in English, so people can understand it. It's very clearly written. You know, the top minds in the government write these laws. And obviously people go on training courses and read about it and think about it and so on. But, you know, I just want to park that thought because I think that's potentially quite relevant. And back to my first question, what can the UK government do about the financial collapse of Carillion? Well, in a way, there's a benefit that it's in statute now. It's a statutory provision because it enables the government to appoint a regulator. You see, I've already mentioned that case law takes time to come through, but a regulator can act swiftly. Now, I've had a period as a financial regulator during my career, and I can't remember the exact performance measurements we were under, but we're talking weeks. We're certainly not talking years. So I would like to see the government, and I'm calling on Prime Minister May to appoint a regulator. It could be the Financial Reporting Council, it could be the Department for Business. You know, that's not for me to decide, but a regulator to look at what this section 172 brackets 1 really means in the light of the Carillion collapse, do an investigation, publish findings, call the directors to account, because that's what you can do as a regulator, hear their side of the story, and let's see if 172 is workable. If 172 is not workable, then is the time to talk about changing the law. But let's not waste time changing the law. We have law. Let's use the opportunity to test the law using a regulator, and we can find out where we are. That's my idea, for what it's worth. Now, something interesting came up on the productivity puzzle. That's in Saturday's Financial Times. Needless to say, they have an article on property in London in this case, but I'm not going to talk about property here as such, but it's very interesting because in this article they quote from a paper produced by the Centre for Economics and Business Research, and I'm quoting, this is a 2015 study, quote, as distances between home and workplace increase, so does commuters' lack of sleep. For example, sleep deprivation in turn is related to low productivity at work, and they estimate that commuting alone has a cost to the UK of £12 billion per year in lost productivity. It doesn't say here what the methodology used is to get to that number, but I can tell you that for definitely the last 20 years, all the people I've worked with, I've sat with in offices, are commuting 1 hour, 1.5 hours minimum each way, every day. So I can definitely attest to the fact that commuting is tiring. So that might just be a little angle on the productivity puzzle. What the answer is, I don't know. Bring fast train lines to London and other major cities. Good solution, I'd like to see that. Probably underground. We've got the Crossrail project coming in London. You know, that's what the government should be spending its money on if they want to talk about relieving the productivity puzzle. So thank you for listening, and that's my thoughts for this week. And do join me again.